Hey everybody, welcome back to the Court of Random Opinion. My name is Lauren Neidigh. As you can see, I'm still not at home. I actually fly back from Australia to California tomorrow, and then I leave California to go back to Florida on Friday. So the video quality, the background, the lighting, it's all going to be a little off for a little bit longer, but I will be home relatively soon. I wanted to give you guys a quick update in this sort of Justin Baldoni versus Blake Lively universe. This one involves Jed Wallace. If you don't remember who Jed Wallace is, he runs the crisis PR firm Street Relations Incorporated out of Texas. And they were hired to do crisis PR for Justin Baldoni when everything was kind of blowing up between Blake and Justin while they were promoting the film. Blake Lively now alleges that Jed Wallace was part of this untraceable smear campaign against her, and she thinks he's some kind of special shadow master who made everyone hate her, but he kind of maintains that while he did follow trends to see what was going on in the public opinion about Justin and about Blake, he didn't really have to do much of anything because organically people were just leaning towards being supportive of Justin and did not like the way that Blake was promoting the film or just in general as a person. Blake Lively actually left him out of her initial lawsuit, although he was mentioned in the CRD complaint. And then Jed Wallace ended up suing her in Texas court. But then after Jed Wallace had filed that lawsuit, she added Jed Wallace as one of the defendants in her amended complaint in the New York court. What we're reading right now is related to the Texas case where Blake Lively filed that huge motion to dismiss, which was over 1,000 pages. Granted, most of it was exhibits that we had seen before. And we're about to read Jed Wallace's response to Blake Lively's motion to dismiss in that Texas case. I'm not going to go over this word for word, but we'll take a look at some of the highlights. Lively peppers her introduction and summary with various insults to and disparaging comments about Street and Wallace, having little to do with the merits of her motion, accusing plaintiffs of judicial harassment and retribution in a far-reaching attempt to muzzle a woman for speaking out about sexual harassment. She laments being hauled into court some 2,000 miles from her home in New York, apparently overlooking that she did the very same thing to these Texans by adding them in the New York litigation weeks after this case was filed, and after she had already sued Wallace in Hays County, Texas. Her New York lawsuit is against 10 defendants on 15 causes of action. Only 3 claims were against Street/Wallace, but 1, intentional infliction of emotional distress, has been withdrawn by Lively as noted by the court. The motion leans heavily on the first-to-file rule, arguing that Lively's New York case, which originally did not include Street or Wallace, is first, even though she amended her complaint to add them several weeks after they sued her in this case. So temporally, Lively's lawsuit against Street and Wallace was second, not first. So a lot of this is obviously still arguing, does this lawsuit belong in Texas or does it belong in New York? And I'm going to be skipping over a lot of that stuff because we've read it to death. Lively's summary of her personal jurisdictional argument is that this court cannot exercise jurisdiction over plaintiff's claim because Miss Lively is not subject to personal jurisdiction in Texas. While this has a certain circular ring to it, we note that Lively does not, as is customary, provide a declaration or affidavit controverting any of the jurisdictional allegations in the amended complaint. Accordingly, they must all be considered in support of plaintiff's prima facie case for jurisdiction and credited over any conflicting evidence. For example, Lively does not contest that prior to this lawsuit, she 1. Filed and verified the Hays County case against Wallace in Texas after paying a filing fee, 2. Paying to have process issued, 3. Contracting with 2 different Texas process server companies to effect service, 4. Making judicial admissions under oath in the Hays County, Texas case regarding her purposeful invocation of the Texas Forum, and 5. Visiting Texas after this lawsuit was filed, republishing the defamatory statements of and concerning plaintiffs. She also challenges venue, forgetting perhaps that she was judicially admitted in the Hays County case that most of the events giving rise to plaintiffs' claims occurred in Texas, and that Street and Wallace suffered almost all of their harm, emotional, reputational, and even physical, in this district. And I guess physical because Jed Wallace reportedly had a heart attack during this whole ordeal because of the stress of this situation, which would make Jed Wallace the second man to be hospitalized over Blake Lively's own failings in the promotion of her own film. Of course, if the complaint fails to state a claim, dismissal is appropriate, but stating the obvious doesn't lead to that reality in this case. Plaintiffs have plausibly pled a claim for defamation, and defendants' affirmative defense relying on California law is both procedurally and substantively improper, as we show below. So this is kind of funny. Lively's lengthy factual background is almost all about her, not Street or Wallace. Making sure we know Miss Lively is an actress and entrepreneur who had, she says, troubles with Justin Baldoni, the movie studio owned by him, his billionaire business partner, The sexual harassment and misconduct that occurred on the set of the film by Baldoni and Wayfair CEO Jamie Heath, and this is just what she's alleging, including Baldoni's allegedly creepy behavior, which Lively describes in great detail, the contractual rider, which included a mandate that Baldoni not retaliate against Miss Lively, and Baldoni's alleged solicitation of assistance from Melissa Nathan and her company, TAG. None of this has any bearing on the motion, Street, or Wallace. In fact, hardly anything is said about Wallace and Street at all, who were first mentioned concerning when they were approached on August 7th, 2024, and began working with TAG on August 9th, 2024. Street and Wallace were never on the set, had never met Lively, never sexually harassed her, never engaged in the purported creepy behavior, and were not parties to or involved in any contractual rider. Their involvement was limited in duration, 3 months, and scope, assisting TAG in social/digital mitigation and remediation. Lively discusses Street's history, including that it was incorporated in California, but it is now a Texas corporation, and that its principal place of business has been Texas for many years. Fun facts that appear untethered to the motion. She then jumps over the August to October time period, when Street/Wallace acted as independent contractors to TAG, landing on December 20th. When she filed a complaint of employment discrimination before the State of California Civil Rights Department. The CRD complaint named Lively as complainant and Baldoni, Wallace, and Street, among others, as respondents, and alleged that they engaged in a variety of conduct in violation of California Government Code Section 12940. The CRD complaint went on to specifically accuse the respondents of conduct which includes sexual harassment, retaliation, failure to investigate, prevent, and/or remedy harassment, and aiding and abetting harassment and retaliation. Of course, these employment allegations were false as to Street and Wallace, who were not Lively's employer, never on the set, and have never been accused before or since, other than in the CRD complaint or draft complaint, of this predatory conduct. The other claims are also untrue. Street/Wallace, for example, never entered into a contract with Lively, nor did they do anything other than monitor social media regarding the film and its stars, Lively and Baldoni. The factual background then discusses more facts about Lively and Baldoni, which predate any involvement by Street or Wallace. For example, TAG provided Baldoni and others a scenario planning document on August 2nd, a week before Street and Wallace were engaged. The next 2 pages of the factual background are all about participants other than Street or Wallace, with one exception, where Wallace allegedly reports that "we are crushing it on Reddit," a comment, if it was made, consistent with his social media monitoring role. Lively then makes the preposterous and fantastical statement in the factual background that at a February 3rd, 2025 hearing in the New York litigation, Friedman, who did not represent Street or Wallace in the case, and who were not then parties to that proceeding, represented that Lively should drop her Hays County case, where she sought to determine the full nature and extent of Wallace's role, and then, without obtaining that information, sue them in New York, which is the reason Lively says she dropped the Hays County case. Fortunately, a transcript of the hearing is furnished, and I've read over that transcript, not too long after that whole hearing happened. And I do agree with what they're saying here. Neither Wallace, Street, Hays County, nor 202 petition, as Lively sometimes calls her Hays County case, are mentioned, and Friedman did not make any representations even remotely like what Lively attributes to him. We're going to skim over a lot of the argument because we've seen most of this stuff before. This court has personal jurisdiction over Lively because she requested affirmative relief in Texas court related to these claims, paid fees to a Texas governmental entity, the Hays County clerk, entered into contracts in Texas with process servers, Assured Civil Process Agency and Aaron Camp, and repeated the defamation in Texas. Lively's contacts with Texas satisfied due process, and the court has jurisdiction over her. Lively relies on a Wallace declaration in the New York litigation, where he discussed that his work was for a California-based entity and that he conducted no work in New York. Lively now twists the declaration into an argument that the focus of her accusation against Street and Wallace was California. But it's not what Street and Wallace purportedly did to her. Rather, it's what she did to them by her defamatory statements, which may have emanated in California, but were aimed at them in Texas. Lively argues that Street and Wallace failed to show that the CRD complaint and the draft complaint alleged that their activities were in Texas. The pertinent point is that the defamation was aimed at Texas, and other than identifying Wallace as a Texas resident, the CRD complaint and draft complaints are silent as to where the sexual harassment and retaliation took place. So Lively is back to chasing her tail because she knows that Street and Wallace did not engage in any sexual harassment on the set of the film, no matter where it was. The first to file rule does not apply and, in any event, does not support dismissal. Plaintiffs are complaining of 2 publications, 1 the CRD complaint and 2 the draft complaint. Each were filed published by Lively through her lawyers, that is, agents, although other agents may have been involved, as discovery may show. In fact, the CRD complaint was even signed by her attorney under oath. They were also published to the media, one of whom was reaching out to Wallace for comment within minutes of the filing, and that was, I believe, Megan Twohey. The complaint in this case challenges Lively's specific statement that plaintiffs are a Texas-based contractor who weaponized the digital army around the country to create, seed, and promote content that appeared to be authentic on social media platforms and internet chat forums, a false statement other than a Texas-based contractor. Lively argues that this statement, that Wallace engaged in a shadow retaliation campaign against an alleged sexual harassment victim, is no more damaging than what Wallace had admitted, that he passively monitored social media. That is a bizarre argument, because under Lively's statement that Wallace and Street weaponized the digital army, if true, would be retaliation for reporting sexual harassment, it would at least impose civil liability, as Lively alleges, on top of being morally heinous, that would be detrimental to one's good name. Beyond that, as explained below, the statement accuses Street and Wallace of criminal misconduct and further injures Wallace and Street in their profession, both categories of defamation per se. Here they're saying she knew she lacked evidence for what she had already published. That fits the requirement for actual malice that the speaker have a reckless disregard for the truth. Lively certainly knew that Wallace had not sexually harassed her, and yet she made the statements anyways and provided them to the press, specifically the New York Times. Lively's statements attack Wallace's profession, skill, and ethics by accusing him of weaponizing a digital army, which is also defamation per se. Wallace has alleged that has caused actual damages and real and projected loss of business in an amount that exceeds $1 million. For the same reasons that Lively's statements attack his profession and constitute damages per se, the defamatory statements have harmed his reputation and anonymity. Here they're getting into the fair report privilege. Under Texas law, the fair report privilege no doubt protects the New York Times for its republication of the draft complaint if the New York Times made that application without actual malice. The fair report privilege only applies to a publication by a newspaper or other periodical. Under Texas law, the fair report privilege does not apply to Lively, as she is not a newspaper or other periodical. California law admittedly does not have the same limitation, but that makes no difference here. The privilege is still inapplicable. Here they're going over the California 47.1 privilege. It says, again, Texas law should apply, and the California Civil Code 47.1 privilege should not. Now we're at the conclusion, which says, neither Wallace nor Street especially want to be involved in this gigantic legal battle between two of the biggest names in Hollywood. After briefly joining the California New York Times case, Street and Wallace chose not to pursue their claims against the newspaper and retreated, in the words of one of Lively's lawyers, into the shadows. Then Lively sued Wallace in Texas, hiring process servers to honk their horns late at night. And Wallace began to see the negative effects on Street's business of being falsely accused of sexually harassing one of the film's leading ladies. So he and his company fought back with this lawsuit. Lively made the false statements, fed them to the press, went to Texas to see what she could find out about Wallace in a judicial proceeding, and then returned to Austin to promote her movie at the South by Southwest Film Festival, and while there, repeated the defamation, an allegation she does not challenge either by pleading, even the motion does not deny it, or proof. Lively has taken advantage of the Texas forum, not to mention Wallace and his company. The motion should be denied. Alright guys, that's the whole of it. I'm gonna be honest, I sometimes think that neither one of these guys has a really good case against the other. I do think that Jed has a good case for dismissal in the New York court, but since I'm not a lawyer, I sometimes look at Lively's motions to dismiss Jed's Texas case, and I think that she has some points there that are hard to ignore. So I'm interested to see how this one would play out. I think ideally Jed Wallace would not be a part of the New York case, of course, and I would love to see Blake Lively have to pay damages to Jed Wallace, but I don't know if I necessarily think that it's going to happen. Let me know what you guys think in the comments below. I'll be keeping up with things while I'm traveling, and hopefully I'll touch base with you guys when I'm back in LA, but that's all I got for now, so I'll see you all soon.